rise. Lords, my lady, in the exchange before lunch, I think where we had arrived was that I have two answers, one which seems to be more attractive than the other to the court, to Miss Rose's point about the more general powers in the 1972 Act. Can I just recap what those are? So our first answer is that what BT is seeking to do here is not to persuade the government to provide more generous provision to specific official pension schemes, but it's arguing that the 1972 Act permits the government to do precisely the same thing that the increases legislation envisages and indeed requires.
What BT is seeking to do here is not to persuade the government to provide more generous provisions, but
to do exactly the same thing by means of the workaround under the 1972 Act, pursuant to the 1972 Act,
yes,
as is envisaged and required by the increases legislation.
yes.
And we say that this is brought into sharp relief, and I don't ask the court to turn it up, but the suggested draft handed up by Miss Rose at the outset this morning, the first version of that provides precisely for an increase in accordance with the specified percentage under a Section 151 direction. And so we say that throws into sharp relief the fact that BT's solution and its proposed use by the government of the broad powers in the 72 Act would entail using those broad powers rather than the very specific legislative regime designed for that particular type of increase. And that's really the specific versus general point that I was proposed that I made at the outset by reference to Vera Cruz. And so we do say that in relation to the specific increases envisaged by Section 59 and Section 59A, those provisions do occupy the field. So that's the first way in which we put the point. Now, I'm going to go back and try again on the second way that we put the point, and I'm going to do it briefly, but I just want to make sure that the court has my submission, even if you're not, at the moment, terribly attracted by it. So if you'll bear with me for a minute, I just want to go back and explain what we say. So the second way in which we respond is we say that the increases legislation occupies the field more broadly in relation to increases to official pensions. And I make 5 points. So the first point is that Section 59 and Section 59A are a specific statutory scheme which specifies a set percentage increase for the entirety of the official pension and ensures, both via Section 59(5) and via Section 59A, that nothing more and nothing less than that is provided. The second point I make is that the increases legislation, so Section 59 and Section 59A, Parliament could have, when it enacted those provisions, but did not, say that it was establishing a floor or a minimum that could be exceeded if the relevant minister deemed it appropriate. So that's something Parliament could have provided for, but it didn't say that. The third point I make is that it so happens in this case that what BT is seeking to say is that the 1972 Act can be used to replicate the provisions, the increases envisaged by the increases legislation. But we say to hold... Yes.
What BT is seeking to say is that
So we say in this case, what BT was seeking to persuade the government to do was to use the Superannuation Act of 1972. So it contends that those broad powers would enable it to provide these specified increases under the increases legislation. And so it's not asking for a more generous provision in this case. But we say that for BT's argument on statutory construction to hold good, they would have to show not only that the 1972 Act permitted that, but also that the 1972 Act permitted increases above the specified levels in the increases legislation to be made to all official pension schemes. Indeed, that's the cornerstone of Miss Rose's argument. She says it does. But we say that that would be inconsistent, and this is the fourth point, with the mandatory provisions of the specific scheme in the increases legislation. So, to put the point another way, if Miss Rose were correct that the broad powers in the 1972 Act allowed individual ministers in respect of all the specific official pension schemes to provide more generous provision, we say what that would result in is a situation which does not accord with the situation prescribed by Parliament in the increases legislation itself, which is that they will all be increased by a specified percentage. And then the fifth point I make is that...
Sorry, can I capture this? So you're saying it would enable different increases for different schemes. Is that what it comes to?
Well, we say that it would enable all of the schemes. She, on her argument, she would have to accept that all of the official pension schemes could be increased to protect them from rises in the cost of in prices at levels which exceed those specified and mandated by the increases legislation.
I'm sorry, I mean, very so. Why did she have to accept that?
Because that's a cornerstone, my lord, of her argument. So she says that she has to give some purpose to the increases legislation. So she says that sets a floor. And she then says, well, the reason that that's its purpose, but what the 1972 Act does is allow for more generous provision to be made to individual schemes. And we say the logic of that argument is that more generous provision could be made to all schemes. And we say that highlights the point, my lord. And the fact is that no more generous increases have ever been made to individual schemes, as a matter of fact, and I can tell you that on instructions.
But why does that help? I mean, it's an enabling power. Whether it's exercised or not is neither here nor there.
My lord raises a fair point, but if what Parliament had intended by enacting the 1972 Act was what was being put to me by the court was that it's very surprising that Parliament precluded ministers from making more generous provision for individual schemes, and it's really a response to that point. But my lord, my fifth submission it deals with that point more directly, which is when the court put to me that it would be surprising if individual schemes could not make more generous provision for indexation, you'll recall that I responded by saying, well, it's perhaps not very surprising because of reasons of fiscal responsibility. But my submission, my lords and my lady, is that both with respect to the court's observation about this being something that's surprising and my response amounts, in effect, to speculation about the policy that's animating this legislation. And we're not in a position in these proceedings to reach any conclusion as to the underlying policy decision. We can only reach such a conclusion by reference to the terms of the legislation that we see. And the terms of the legislation that we see are the increases legislation, which mandate this particular specified increase, no more, no less. And so I hope that assists, but that's why we do put our answer in both ways. Now, I have to deal with, I think, 2 or 3 other arguments that Ms Rose made. So, one argument that she made was that the increases legislation, she said it doesn't actually itself provide for GMP indexation, because that's provided for under section 109 of the 1993 Pension Schemes Act. So in other words, she says that it follows from that the increases legislation is not an exhaustive scheme, and we say that there are a number of difficulties with this submission. So the first difficulty is that section 109 is obviously different from the general power under the 1972 Act, and that is because section 109 expressly and specifically requires indexation of GMPs. Now, we don't dispute the fact that even though the increases legislation, we say, occupied the field here, that Parliament remained free to enact specific legislation which expressly required certain increases, as it did with section 109. Indeed, we say that's expressly envisaged in section 59(5), which carves out GMP because it recognises it's being indexed elsewhere. But the specific and express provision for increases of GMP under section 109, we say, lie in stark contrast to the general powers being relied on by BT under the 1972 Act.
I may be wrong, but I think her major point, or her sole point on this aspect, was it's not correct to say that 59 and 59A occupy the whole field. That was the point.
So,
because you've got section 109.
So what she then needs to go on to say, my lord, is to say, well, it doesn't occupy the field and, so that's not enough for her purposes. She needs to say, and sections 1 and 2 of the 1972 Act do provide this power. And so the first point that I'm addressing is that the section 109 duty does not help on that second stage. So it's not enough for her to say, we say, that that the field is not occupied. I've got some other submissions to make on this point, but we say she then needs to go on and say, well, the field is not occupied, but that doesn't answer the question as to whether the 1972 Act provides these powers.
Well, it does, because those powers are framed in the most general terms you could imagine. So any provision of this type falls within them, unless the ground is preemptively, so to speak, totally excluded by legislation which one has to interpret as being not only specific and mandatory, but also exclusive of any alternative means.
Well, my lord, the first point I make in response to that submission is that the section 109 provision is specific and is not of the same nature as the general powers in the 1972 Act. But we then say, the second issue we say is, and really the point there is that you can't use the 1993 Act to interpret section 2. That's really the point I'm making. But the other premise for Ms Rose's submission is that the section 109 power is somehow separate and hermetically sealed off from the increases legislation. But we say that it's not, because it's precisely the section 109 power, and in fact its predecessor, which dealt with the AP, that is envisaged in section 59(5) when it refers to the carve-out of the GMP indexation. So what section 59(5) is doing is recognising that there is a statutory provision providing for indexation of GMP, and it's carving it out, switching it off, unless it needs to be switched back on under 59A. So Ms Rose also raised an argument. She relied on the PCSPS rules, and she handed up a rule showing that they have in fact been amended pursuant to the 1972 Act in order to implement the requirement under section 109. And the court will recall you saw rule 1.13a.
I don't think she handed it up. I thought it was in the bundle.
It may have been in the bundle. I'm not. I may have been in the bundle.
Yeah.
But we say that this doesn't help BT, because what BT needs to show is that the 1972 Act can be used as a freestanding basis, statutory basis, for indexing official pensions. And Miss Rose's example doesn't show that. What her example shows is that the 1972 Act was being used here to reflect the statutory requirement that was the statutory requirement under Section 109. So it was the statutory requirement that required the GMP to be indexed, and then the 1972 Act was being used perhaps for administrative good order to reflect that in the rules. It's not an example of it being used as a freestanding provision.
I think you're, in a sense, the arguments are sort of crossing each other without meeting. My understanding was, from the skeleton arguments, that, and from what I said below, that your case was your case was that 59 and 59A cover the whole field in relation to increases in pensions for public service personnel.
Yes.
Ms. Rose then comes back and says, well, yeah, but that's not correct, because Section 109 has done, and look and see how it's actually being utilised. You're actually now raising a separate point, which is to say, well, even if it doesn't cover the entire field, nonetheless the 1972 Act isn't appropriate for effecting these changes.
Well, my Lord,
That's what it seems like to me at the moment, I have to say. And I'm not sure how far we can take this, to be honest.
well, my Lord, can I try and put it in context? Because you have my primary submission, which is that the field is covered.
Yes.
And on that primary submission, we say, so in relation to Section 109, we say the field is covered, and Section 109 is expressly acknowledged within the increases legislation through Section 59.5. And it's only when that's not happening that 59A switches back on. That's my primary submission.
It is quite a strong thing for asking us to accept, which is that by implication, because it's nowhere expressed, Parliament has laid down that this is the only machinery that can be used to achieve this kind of purpose, despite the apparently very wide wording of the 1972 Act.
Well, my Lord, with respect, we say not, because what the court is faced with doing, there are competing, in a sense, we would turn that around and say it's a strong thing in the other direction, that where Parliament has laid down a mandatory specified percentage in legislation explicitly directed to this issue, that later general powers, and this is really the Vera Cruz point, can be used to cut across that.
You could have some sort of statutory implication that you can't use the 72 Act to undermine the sections 59 and 59A, but that, they say, is not what would be happening. They wouldn't be undermining that because they'd be providing, and they'd give an example of the way that they'd be using the 72 Act to achieve, so far as the people benefiting or intended to benefit from the 59 and 59A, they'd be achieving exactly the same end. But that's not your argument.
Well, my Lord, it is part of our argument, because what we say is that where the field is occupied, so I hope I've made clear that we have a broader argument that the whole field is occupied.
Yes, no,
that was the point I came back to. And then we have a narrower response, which is that where the very thing that the increases legislation is directed to is at issue, then you can't circumvent that statutory mechanism by doing it another way. And so we do rely on both points. And we do say as well, in relation to the first point, I think I've made this submission already, that were it, in circumstances where Parliament has mandated a particular and finely calibrated statutory scheme, if it had been Parliament's intention that more generous provision could be made outside those provisions, it would have said so in the Act, but it doesn't say that. And so we turn round the proposition put to me by Lord Justice Henderson, and we say, well, we say that it's an extraordinary thing, that it would be an extraordinary thing that when Parliament has determined that this is the system, more general powers not directed to that particular issue can be used to undercut it. And that's how we put the point. I think I have one further argument to deal with, which wasn't one advanced orally by Miss Rose, but it's in her skeleton argument, and I think just for the sake of good order, I ought to deal with it. So she makes an argument at paragraph 889. Can we take up their skeleton? So this is in the core bundle behind tab 2. And so what's said here, so this relies, it's paragraph 89 on page 16.24. And this is part of her submission that the increases legislation does not prevent...
Paragraph 89 of the appellant's skeleton.
Yes, behind tab 2 of the core bundle.
Right, I've taken it out. So this is internal page 24.
No, it's yes, internal page 24. The bundle pagination is 16.24. So this is part of Miss Rose's argument that the increases legislation doesn't prevent more generous provision but via other mechanisms. So just to locate the context of this. And she says it's clear, for example, from the wording of section 59.5, which provides that increases are to be calculated by reference to the basic rate of the pension, which is in turn defined, and you see the footnote there. And I think that Miss Rose's Junior is just that's not in the bundle so far, but has just distributed that, so that should make its way to your authorities bundle. But I don't need to turn it up because I can just give my answer by reference to this. So that relies on section 17 of the 1971 Act, and it says that the basic rate of the pension is in turn defined as the annual rate of a pension apart from any increase under or by reference to this Act, or any enactment repealed by this Act, or any corresponding increase made otherwise than under or by reference to this Act. And so what she says is that this makes clear that Parliament envisaged that there would be other increases under other acts. So that's their argument. And what we say to that is that the purpose of the relevant wording in section 17 is, we say, to ensure, there's an obvious purpose for it, and it's to ensure that there is no double indexation or indexation of indexation where a pension has already been increased by non-legislative means. And if we can turn back to the authorities bundle at tab 2, so the first authorities bundle at tab 2, and back to the 1971 Act, and in particular, if you turn to Schedule 2 to the Act, which starts on page 12, what you see there is a list of official pensions which are brought within the compass of the increases legislation. And that list includes a number of examples of pension schemes which had no legislative basis. And so, for example, if you look at paragraph 39 on page 19, that's an example of one. And so that our short point is that since these were not legislative schemes, then increases to pensions under those schemes may have been, and I'm quoting from the relevant words of section 17, made otherwise than under or by reference to this Act or an enactment going back to revealed by it, sorry. So, and that we say is the explanation for the wording in section 17, and we say that it doesn't materially assist.
Which section 17 are you looking at? Sorry.
Section
I've
17,
lost you now.
which I was footnoted in Miss Rose's skeleton. As I say, this is not a point that she advanced orally, but because it's in her skeleton, I did want to explain to you what our answer to it is.
So your answer is in Schedule 2 to the 1971 Act.
Yes, and the point is that that what was brought within the scope of this increases legislation are pensions which had been, the basis for which was not legislation. And so that's an explanation for section 17. So those are my submissions on ground 3. May I turn to ground 4, which is improper purpose? Now, Ms. Rose's argument on this ground was as follows, as I understood it. So she said that where there are two possible statutory routes available to achieve a particular purpose, because on this hypothesis she succeeded on the vires point. So where there are two routes available, and one route involves as an unintended consequence the imposition of a burden on a private party, she says it can't be an improper purpose to select the route which avoids the burden. And she says, on the contrary, that's the function of the principle of proportionality. That's the government acting proportionately. So I think that's an accurate summary of her submission. And we say that the difficulty with this submission is that it does not properly characterise what is going on here, because the government didn't face a simple choice, and this was the point I made at the outset, between imposing a burden on BT or avoiding the imposition of that burden. And that's because the avoidance of the financial burden on BT could only come at the cost of BT's Section B pensioners. And that's why, as I said at the outset, that the position in this case is very different to the compulsory purchase example that Miss Rose gave yesterday. And we say that in those circumstances, in circumstances where the government was faced with was being asked deliberately to choose a statutory route which preferred BT's private interests over the private interests of its pensioners, we say that in our submission that would be acting for an improper purpose. In circumstances where the only reason for choosing that route would be to accede to the proposals of BT. So the only reason for choosing that route rather than the normal Section 59A route would be to avoid the burden on BT. But we say in circumstances where that entails essentially preferring BT's interests over those of its pensioners, that would not be a proper purpose, given that the Act that we are looking at here for these purposes is the 1972 Act. And the 1972 Act is focused solely on making public sector pension schemes. So nothing about that Act permits powers to be used solely for the purpose of preferring one party's private interests over another. And so that's the way that we put the point. So
what is this? Is this a kind of a Padfield argument?
It's a Padfield argument. So
it's a Padfield argument.
Yes, and it was accepted by the Divisional Court. And Miss Rose says, well, it shouldn't have been accepted because this is all just the government acting proportionately. But we say not so, because this is not a case. It's not a case. It's not a one-way street type of case where the government is, where one's in a position of the government choosing between two statutory routes in circumstances where one impacts less on a private party. Because the precise question, and you see this time and time again in the contemporaneous documents, that the government was concerned with was the question of whether it should be preferring BT's private interests over those of its Section B pensioners. And so we say, in circumstances where, absent this whole BT issue, it's obvious that the route chosen would have been Section 59A, that it can't be a good reason to use the 1972 Act instead, solely on the basis that the government wishes to prefer BT's interests over those of its pensioners. It's a short point, and that's how we put it. But we say the Divisional Court was quite right to find that using the 1972 Act powers for that purpose would not have been proper, because it's simply not what's envisaged by the Act. And perhaps it's useful just to go back.
My instinctively one feels you have to put it in a slightly different way to make it easily Padfield. In Padfield, you're acting outside the purpose of the legislation. And somehow one feels you need to, if you're going to make good this submission, you need to tie it to the, you need to identify what is the purpose of the 1972 Act.
Yes.
And why it is that what is being done falls outside that purpose. I think that's I'm not sure the way you've articulated
My
it.
Lord, I quite agree, and I'm going to take you now to the 1972 Act, if I may, because I quite agree with the point that my Lord's just put to me. And it's in the first authorities bundle behind tab 3. And you can see the purpose of the Act, apart from anything else, from the long title, an Act to amend the law relating to pensions and other similar benefits payable to or in respect of persons in certain employment, to provide for distribution without proof of title of certain sums due to or in respect of certain deceased persons, to abolish and so on. And then what you see from the terms of the Act is it's all about making pension schemes for civil servants. That's what the purpose of the Act is. And so, my Lord, to grapple directly with the point that you've just put to me, we say that's the purpose of the Act. So there's nothing in that purpose about weighing up anyone's private interests. It's all about making provision for civil service pensions. And then, in the circumstances of this case, it's clear that the government, were it not for the BT issue, would have used the increases legislation. That's what it ended up doing anyway. So the Section 59A route is the route that's always been used to provide indexation. And so what we say is that had the government instead acceded to BT's...
Hang on, even that's quite... I think that's a bit, if I may say so, a bit too wide.
Right.
I certainly see your point about identifying the purpose of the legislation. As I see it, I understand the
Yes.
that the purpose of the legislation is to provide for schemes for civil servants. That I
Yes.
understand. And you say that what's being suggested here is preferring purely private interests, which are completely outside the civil service schemes.
Yes, that's...
I understand that submission. But then you go on to make, just now, rather quickly, make a rather broad point, which is 59A has always been used for indexation. We know that's not true because Section 109 has been used.
Well, my Lord, can I put the point then this way? So that the government would not have used Section 2 to provide indexation in this case. And indeed, that has to be uncontroversible because the government's position is that it doesn't provide those powers to do it. And you can see in the evidence of Mr.
You've already assumed, you have to assume against yourself now that you've lost on the vires point.
Yes.
So these are alternative means which can be achieved in order to do precisely what you say can't be done, which
Yes.
is to provide an increase.
My Lord makes a fair point, and I can't pray and aid the illegality, and that's a fair point, my Lord. But what we do say is that when one looks at the evidence of Mr. Kirk and also of the contemporaneous documents, what the government talks about all the way through is the normal route for providing these increases. And so...
You may be right about that. You may be right about that. But all I can say is I hope I haven't misinterpreted what Ms. Rose was saying, but I'd understood her to say actually it's only been used since 2016.
No, that's not correct. My junior will find me the relevant part in the evidence, but that's not correct. I don't think she did say that.
What I mean, my Lord, is that 59A has only been used to cover anomalous gaps for pensioners living abroad until 2016, which is the only time that it was ever used to index GMP.
I understood. I'm afraid
on an expressly interim basis. There was no practice of using 59A for across-the-board indexation of GMP.
That was the point I was seeking to.
My Lord, on that point, can we perhaps, while we're on this point, look at the judgment, because that sets out the position. So the judgment in Core Bundle tab 5, paragraph 142 at page 63.
Which paragraph?
142, my Lord. So page
132.
42, page 63.
Yes.
So what you see there is, since 1975, there has been an increase order made under section 59.1 in every single year bar 2, in both of which there was no positive inflation in the preceding year. Since 1979, there have been 4 section 59A directions, and there has at all times been a section 59A direction in force. each Section 59A direction has revoked the previous one and added to the categories of cases which are covered by it. In effect, whenever the government has identified a class of pensioner whose GMP is for whatever reason not being indexed, a Section 59A direction has been made to index that pension. This is what was done by the 2016 direction, and although it was wider in scope than prior directions, its rationale was the same. And so that's really the point that I'm making, that this is how it's always been done. So where GMP is not being indexed under, for example, Section 109, then what the government's always done is it's made good its obligation, its overriding obligation under Section 59(1) to ensure that the entirety of the official pension is increased, is uprated, by making a Section 59A direction. And so you see in the evidence that that's described by Mr. Kirk as the normal route, and that it is the normal route. That's been the practice, the uniform practice.
Yeah, well, historically that may well be right, but that doesn't answer the point, does it? That if you have a general power, which is not, it would not be out for vires to invoke. Why can't you use it for the first time? That should be a first time for any.
So, my lord, my answer to that is that in those circumstances, the reason one has to look at the reason or the purpose for using the power under the 1972 Act. And the reason or the purpose for using that power would be, according to Miss Rose, to prevent a burden being incurred by BT.
Well, that's the motive, but the purpose is to increase the pensions of the CPS, whatever they're called, the pension of the civil service pensioners, by the desired amount of annual.
Well, my lord, we don't see it like that. And so my submission is that that the purpose of using that, one has to ask, what's the purpose of using that provision as opposed to the provision that's always been used? So really it comes down to the characterisation and of what the government would be doing and the reason why it's doing it. And so it's not enough to say, it's not enough, Miss Rose, to say, well, the section, the 1972 Act is being used to increase pensions. That's true as far as it goes. Of course it would be being used to increase pensions. But one has to ask, why is the government using that power as opposed to the bespoke statutory scheme? And the reason it would be using that power would be to save BT money. That's the short point, and it all comes down to how one characterises the reason for using that power. And we say that in circumstances where this is not a simple one-way traffic situation, because the government was faced with competing interests, financial interests, it was not a proper purpose it would not have been a proper purpose to decide to use that power in order to prefer BT's financial interests over those of its pensioners. And that's really how we put the point. So we say it's not good enough to ask in broad terms, why is this power being used?
Presumably your case is that, I suppose it goes back to the policy point in a way, that your point would be that this is the sort of challenge that a member of the scheme might make.
Lord,
It
yes.
requires somebody to come along and say, I'm sorry, this is outside your powers under the Act. And they would bring judicial review proceedings partly on that basis.
My lord, yes, and in fact, there's a certain artificiality about grounds 3, 4 and 5, because particularly ground 5, which I'm going to come on to, because ground 5 is all about A1, P1 for the workaround as a standalone option. But of course our case is that was never put to us as a standalone option. We never considered it as a standalone option, and we never reached a view as to whether or not it engaged A1, P1. And so, my lord, we say that if we're right on grounds 1 and 2, then obviously these grounds fall away, and one doesn't need to get into the difficult question of determining them without the pensioners being here. So, if I'm...
I think we've got. Have you dealt with ground 4?
I've dealt with ground 4, and I'm just looking at the time. May I move on to ground 5?
Please.
So
you've just made your first point on ground 5, which is
I did, and we see
A1, P1's never presented, you say, as such, as a standalone.
no, and my lords, my lady, have my submissions about about that under ground 1, and we can see, in fact, from the judgment below, what the court said about this. And so we're back into the core bundle behind tab 5, this is the Divisional Court's judgment. Can I take you, please, to paragraph 177, which is the start of the court's analysis of the ground 5 issue on page 73.
You haven't got any, sorry, reverting slightly to ground 4. Are the facts of this case so alien to any other that's been the subject of a decision that there's no other decision that could help us on this, apart from the general Padfield principle, which we're all familiar with? Is there anything that's approaching the sort of factual situation which we're in, preferring private interest by using what you say is a statute geared to some sort of government matters?
Well,
Is there anything along those lines?
Well, we say that although the facts are different, and I readily accept this, that the principles, going back to what the Divisional Court said under ground 4, if you look at paragraphs 160 and 161, and they refer to Dodd and Salisbury and Yeovil Railway Company, and then Porter and McGill, and we accept that, as Ms Rose submitted, the facts are different in those cases to the present case, but we do say that the underlying point of principle applies. And you see that in the second part of the McGill excerpt. So the power at issue in the particular case is section 32 of the Housing Act, which conferred powers on local authorities to dispose of land held by them, subject to conditions specified in the Act. Thus, a local authority could dispose of its property subject to the provisions of the Act to promote any public purpose for which such power was conferred, but could not lawfully do so for the purpose of promoting the electoral advantage of any party represented on the council. So just pausing there and going back to the point put to me by Lord Justice Henderson, it was still true in that case that what was being done was the disposal of property.
Yeah.
And so, transposing that to the present case, we accept that what would be done under the 1972 Act would be the increases of pensions. But that's not the end of the analysis, because the question is, why are you using this power? And so that's really the point we make. And of course, we're not suggesting anything analogous to the facts in Porter and McGill, but we do say that analysis holds, that it's not good enough simply to say, are you increasing the pensions? Are you selling the houses? You have to look at the purpose for which that provision has been invoked. No, my Lord, I'm grateful. That was a helpful intervention. So to go back to paragraph 177 of the judgment at page 73, this is the Divisional Court recognising the, as I put it, artificiality rather of this point in this litigation, because the court there says it's probably unnecessary to decide this issue, as the consultation response made it clear that the government didn't want to pursue an option that would involve complicated and contentious legal issues. If necessary, however, we would hold that the Section B members' property rights are engaged in this case. And of course, as the court's aware, our position, the government's position, is that BT did not advance the PCSPS workaround as a standalone option. And so in these circumstances, the government did not have to address its mind to whether the workaround alone would engage A1P1. And for all the reasons I gave this morning, the government in fact didn't do that, because where in the contemporaneous documents the government is considering A1P1, we say it's clear that it's doing so in respect of the statutory override. It either refers to the statutory override specifically, or it's looking in the round at all of the proposals put, which include the statutory override. And so we say that it's unsurprising that the government reached the view that those options would have engaged A1P1 because BT itself accepted it, because it accepted that the statutory override engages that provision. And so we say that our primary position is that the government did not actually reach a freestanding conclusion on this point because it wasn't addressing the question of the workaround as a freestanding response. And that's why the Divisional Court says what it says at paragraph 177. But if we're wrong on all of this, and so if the court's not with me on the documents and on what the scope of the decision was, and the court finds that in fact BT did advance the workaround as a standalone solution, and that the government did conclude that it would engage Article 1 of Protocol 1. So if contrary to my arguments, that's the conclusion.
That's a pretty, I mean, you're now getting into a very contorted position because your submission here is the government never considered it in this way. I mean, what you can say is, well, if that is the position, what we would now say
exactly,
is X.
and that's.
But I think you're in a very difficult position to say it didn't consider it, but if it did,
Well, my lord, that's really
your client should know what it did consider, what it didn't.
No, and I don't shy away from that, and that's why we say that actually ground one alone, Miss Rose accepts that she's got to win on all grounds, but that's why we say ground one is dispositive of this case because the government didn't consider it, and so if we're right on that. And that's what the court finds.
I don't want to stop you advancing an argument if you want to. I'm just simply saying there's a degree of artificiality.
My lord, and that's what I don't shy away from. And that's what I'm trying to confront because there is an element of artificiality, and it goes in my submission to how this point is addressed. Because I sense a certain reluctance on the part of the court to grapple with this point. But we say that because of the absence of any BT pension scheme members, but we say that, and so that's why I wanted to confront this issue of artificiality, which is there, but we do say that if the court finds, if you find against me on those points, if you find in fact it was advanced as a standalone option, in fact the government considered
it. You lose
it,
on grounds 1 and 2.
Yes, then, and in fact this was considered in isolation, then we say that the conclusion on the legal point is right. And I want to make my submissions. I want to first of all go back to the PCSU case, which is in the second authorities bundle at tab 51. And so that's Authorities Bundle 2, tab 51. And we say that this case does bear analogies with the present case because it raised the question whether the reduction of benefits under the Civil Service Compensation Scheme engaged Article 1 of the first protocol. And going back to the paragraphs that Miss Rose took you to, I just want to highlight some additional things in those paragraphs. And so, starting at paragraph 68 on page 1556, you can see there the excerpt from the Kopesky case, which Miss Rose took you to. And then moving on, and of course that says that possessions can be either existing possessions or assets, or assets including claims in respect of which the applicant can argue that he or she has at least a legitimate expectation of obtaining. And then at 69, you see that the term legitimate expectation is an autonomous concept and doesn't necessarily correspond to the concept of legitimate expectation as used in domestic public law, see Stretch. And then at paragraph 70 to 71, Lord Justice Sales there considered whether civil servants have had a legitimate expectation to payments under the scheme in circumstances where they weren't contractually entitled to them. And you'll see in those paragraphs that emphasis was placed and you see the submissions at 70 in the first part of 71, and then at the top of page 1557 it says, in my view. Does the court have that? So in my view, that is the position here. The claim for legitimate expectations for individual civil servants based on the stated entitlements in the CSCS is a particularly strong one, given the long-standing nature of the administrative practice in question. The entitlements in the CSCS are set out in clear and specific terms. They're akin to contract rights. And then you see at paragraph 72, on the footing that individual civil servants would have had legitimate expectations enforceable in domestic public law, then it's clear these would be classified as possessions for the purposes of A1P1. But then at 73, even if for some reason entitlements under the CSCS did not qualify as legitimate expectations in domestic law, they would still, in my view, qualify as possessions for the purposes of A1P1 on the basis they come within the autonomous concept. The entitlements are clear and precise, they're invariably complied with by government, they're akin to contractual employment rights, and they're given special recognition and protection under domestic legislation. So, yes, Mr. Johnson's asking me just to read the second part of paragraph 72. So just going up again, that is so even though they would only come into play if certain contingencies occurred, even in advance of those contingencies arising, a civil servant would be entitled to expect that if they did occur, payments would be paid to him in accordance with the CSCS, absent any legislative change by the Minister to the terms of the CSCS beforehand. While particular entitlements under the CSCS remain part of it, they would be enforceable as domestic law legitimate expectations. So, applying these principles, we make the following submissions. So we say first, our first submission is that BT accepts that there is an Article 1, Protocol number 1, right to indexation whenever the PCSPS is indexed using the increases legislation, and presumably any amendment, modification or reenactment of it. Secondly, we say that the obvious assumption underlying Rule 10.2, read with Rule 1.2, little 1, was that the indexation... 10.2, read with Rule 1.2, little 1, which I took you to earlier, was that the indexation would be done using the increases legislation as amended, modified or reenacted. And we say that the Divisional Court was correct to make that finding.
Was that 1.21, was that in Section B or Section A?
Section B. We say that the Divisional Court was correct to make this finding at paragraph 178 of the judgment, and perhaps we could turn the judgment up again behind tab 5 in the core bundle and go to the relevant passages. So paragraph 178 is at page 73.
I'm just writing down here the obvious assumption
Underlying
11.2, read with 1.21 in Section B, was that indexation
would be done using the increases legislation. And just turning to the court's judgment below. So the point that emerges clearly from the court's judgment below is that the source of the legitimate expectation identified by the court, there are two sources. One is the rule itself, and we see that from paragraph 178. So the starting point is the terms of the Scheme B rules. We agree with the Treasury that the obvious assumption underlying Rule 10.2 is that indexation would be done using the increases legislation. and that in that way the Section B members would benefit as if their pension was payable under the PCSPS. That can be the only purpose of referring to that legislation, including under Rule 1.21, as it may have been or may from time to time be amended, modified or reenacted. And we do preanate the points I made at the very outset this morning, which I made in the context of showing that there was a doubt about the construction point, but I took you to the Section A rules, and I showed you that unequivocally is intended, as BT accepts, to mirror the provision in the PCSPS, and yet its rule on increases is drafted in exactly the same way. And although this point is related to the construction point, which the court is not to determine, it's a separate point analytically, because what we say is that even if stretch demonstrates that even if you have an obligation that's unenforceable as a matter of public law, it can still give rise to a legitimate expectation. And so what we're saying is that when one looks at the way the rule is drafted, including Rule 1.2, which brings into the scope for subsequent enactment, and when one looks at the Section A equivalent rule, we say that that in itself was enough to give the pensioners an expectation that they would get these increases, because it was assumed, the underlying assumption was that the increases would take place via the increases legislation. Third, we say that there has been an invariable...
Who's created that expectation?
Well, that's an expectation which is created as a matter of from BT's rules.
No, I know that, but
yes.
in the case, if you're seeking to hold the government to a legitimate expectation, surely it has to be a legitimate expectation promoted by the government.
Well, my lord, we say in this respect not, because what one's holding the government to here is not a legitimate expectation as a matter of public law. We're looking at legitimate expectation through a different lens, because we're not holding the government to a legitimate expectation. We're asking whether these are possessions, and we're looking at it through the lens of the Strasbourg cases, which say that you don't need to have an actual property. If you can show that you've got a legitimate expectation to some sort of asset, then that establishes the property right. Then what we're holding the government to, what A1P1 then holds the government to, is a duty not to interfere with that property right. But my lord, yesterday Miss Rose accepted, under ground 5, that the Section A pensioners do have a legitimate expectation, do have a property right as a result of the way that the rules were drafted. And so we say that by parity of reasoning, the rules under Section B2 give the pensioners a legitimate expectation that the increases would be done via the increases legislation. And we see, and this is the point that Miss Rose objected to at the outset, we see that the pensioners say that themselves. So they say, well, we expected to be given these increases. And
you have to go so that's quite difficult. I can quite see that the legitimate expectation is, because the rules themselves say this, that if there are any increases under the increases legislation, we will benefit from it. I mean, that's clear enough. That's the express terms. The legitimate expectation you are promoting here
yes,
is that the government will only provide
yes,
increases through those.
yes, that's right. And we say,
why is that so? That seems slightly odd.
well, my lord, we say that that's so because we say, as the Divisional Court held, why would they have agreed to that provision? The reason the reference to the increases legislation is in there is because that's the way that it's done. And so none of these, well, I can't make the submission that none of that's going too far, but what we see is that at least some of these pensioners in the correspondence did not appreciate that BT might, and the government might later say, well, actually, we're going to affect these increases to the PCSPS by some other means.
I can quite see it. So I'm trying to trying to, in a sense, compartmentalize the origin of this, and
Yes.
who's making the representations. Plainly, insofar as they're in the rules of the BT private pension scheme, you may have all sorts of legal arguments for saying the BT shouldn't alter them in a way that would diminish that right, particularly if people have moved, say, from Section A to Section B. I mean, that is reasonably straightforward, I'd have thought. I'm not saying there is a cause of action, but you could see there are all sorts of reasons about those expectations shouldn't be undermined and implied or express representations. But you are seeking to pin this particular one on a representation about the way the government, not BT, will act in the future. That's the leap.
No, my lord, I'm not seeking to do that. Let me try and rephrase what I said, because I wasn't clear. So, what we say is that the rules. So let me start with something that Miss Rose accepted yesterday. She accepted that the Section A pensioners have a legitimate expectation to receive indexation because she accepts that the rules provide for mirroring. And so we say, by parity of reasoning, the Section B pensioners, on the basis of the rules, this is the first of the findings made by the Divisional Court, on the basis of the rules, have the same legitimate expectation. Now, it's closely related to the construction point that the court can't decide, is not in a position to decide. But it's not the same as the construction point, because what we're saying is, on the construction of rule, there's a question of construction.
Well, I understand it's not the same. I mean, they're different issues. The question one is what do the rules mean?
Yes.
And that's a completely separate issue from this issue. Which
Yes.
is a different issue.
Well, it's a related issue, my lord, in the sense that what I'm saying is that the rules on their face would have caused pensioners to believe, or some pensioners to believe, that they had a right to indexation and that would be carried out under the increases legislation. And one of the reasons I say that is because it's accepted that the Section A pensioners would, on the basis of precisely the same rule. So, well, Miss Rose can make her points in reply, but I'm explaining my submission.
So you sound as though you're relying very heavily on what you say Miss Rose conceded in relation to the Section A.
No, I don't rely very heavily on it. I'm responding. I use that to respond to my Lord's point that one can't have a legitimate expectation emanating from something a private party has done. And endeavouring to answer my Lord's point, I said that Miss Rose effectively agreed that you can.
The point I was trying to make was simply that the legitimate expectation here isn't a legitimate expectation of what BT will do. You're relying on a legitimate expectation of somebody who's outside the terms of this trust. They're not involved in this trust at all at the moment. They may have been in the past. That's a different issue which you haven't yet addressed. But the difficulty as I see it, I'm not saying you're wrong, but the obvious logistical difficulty is that you're seeking to pin as a possession something which you say a person wholly detached from this private scheme is said to have said that they will do.
My Lord, no. Can I just? I'm not seeking to say that. Can I reframe what I'm seeking to say in the hope that I'm clearer? So what we say is that the question of legitimate expectation needs to be looked at broadly. It's an autonomous concept.
Yeah.
The question here is, did the Section B pensioners, so leave aside where this emanates from at the moment, did the Section B pensioners have a legitimate expectation that they would receive these increases? So that's the question. So, and then we say, yes, they did, and we rely on two things to establish that they did. And these two things are different in nature. They were both relied on by the Divisional Court. The first is that the pensioners, and this is the point at 178 of the Divisional Court's judgment, the first point is that the pensioners, looking at the Scheme B rules, would have the obvious assumption, as the Divisional Court put it, underlying the rules, is that the increases would have taken place via the increases legislation, and that's why the increases legislation is referred to in terms. And we do pray in aid the fact that under Section A, that the rule is drafted in exactly the same way. And so we say for the purposes of judging whether there's legitimate expectation, It's not right to say, well, they only had a legitimate expectation that they would get an increase if the increases legislation were used, because actually the obvious assumption underlying all of this is that it would be used. That's the first plank of the argument. And then, as the Divisional Court says at 179, building on that, so building on the rules themselves, it's the fact that the invariable administrative practice since then has been to use the increases legislation for indexation increases. And so there you have the point about the section 59A directions always being in place, that this has been the invariable administrative practice, that where GMP indexation is not being provided elsewhere, it will be done via section 59A. So essentially those are the two planks underlying the legitimate expectation, and we say it's really the combination of those things. So it's the combination of the rules themselves and the fact that this is how it's always been done. And what I sought to show the court in opening was that at least some of the pensioners take the same view.
Yes, but I mean, that was such a small number.
My lady, yes, but we would say that it doesn't matter, one is enough in a sense, because you just need one person to say I had a legitimate expectation, and then you're engaging A1P1 and you're into justification.
Surely the test has to be an objective one, doesn't it? And otherwise you just find one letter from one pensioner and say, hey presto, here's a legitimate expectation.
My lord, yes, we agree that it has to be an objective test.
That is how these letters relevant. You don't help us before.
Because the question is, objectively, so it's an objective test. The court has to ascertain objectively what the legitimate expectation of these pensioners was. But relevant to that question is what they thought. That's
why? It's completely irrelevant.
Well, my lord, no, I disagree with that. We say that if somebody is coming to court saying, I had a legitimate expectation that I would get this asset, then their subjective belief is something that needs to be considered by the court and taken into account. It's not irrelevant in our submission. It's a relevant factor that goes to the determination of the test. But of course it's an objective test, my lord's right, in the sense that the answer given by the pensioner is not conclusive of the point. But in the same way that when courts are deciding lots of objective tests, subjective evidence is relevant to that question.
I don't flog my own point, but if I could revert, you make the point, which I understand, that by virtue of what the rules contain themselves, there is, you say, an expectation, a legitimate expectation, on the part of the members of the relevant members of the scheme, section B, that they would be receiving increases via, I think you use the word via, increases under the increases legislation.
Yes.
Now, what we understand from the authorities is that to give right, even under the autonomous principle, I think, to give rise to such an expectation, there must be a clear, unequivocal, unconditional and unequivocal representation.
Well, my lord, just pausing there, we say that's why I took you to PCS, the Civil Compensation Scheme case, because what the basis there for the representation was the invariable administrative practice.
So you don't rely upon the representation point?
No, well, we say that is, so broadly speaking, one needs a representation. It doesn't need to be a statement. It can be, the representation can consist of the invariable administrative practice. That amounts to a representation.
So there must be found a representation. Leave aside for the moment administrative. Who is making this representation? Who is making, and you're relying upon the government's practice in relation to a different category of people. So, because the government isn't delivering the increases to these pensioners. These are pensioners under a private scheme. So the administrative practice and therefore the representation, it may be said against you, is being made to and vis-a-vis members of the civil service schemes, not these private pensioners. So what I'm trying to understand all the time through my question with this is how you link what may be representations under the trust deed, under the BT trust deed itself, the BT itself, how you relate that to something which is about what the government does, and it goes back to this question of who is making this representation. There must be a connection there somewhere.
Well, my lord, what we say, if I can grapple directly, I hope, with my lord's question. So what we say is that you start with the scheme rules, and so the scheme rules provide a read across to the PCSPS, and they directly refer to section 59 and section 59A of the increases legislation. And so they say when increases are being provided under that scheme, you, the BT private pensioners, will get that increase. That's the starting point. Now we say that when one is thinking, well, what would the obvious assumption of pensioners be when joining the Section B scheme and looking at Rule 10.2, it wouldn't be confined to a belief that what this was providing was an indexation only in circumstances where the increases legislation was being used. The reason that the increases legislation is referred to is because that's the means by which this generally takes place, in fact invariably takes place. And so that's the starting point. And then you moved, then to make good that second proposition, we say, well, in fact, on every occasion where the government has recognised that GMP indexation is not taking place through Section 109, it has switched on under Section 59A that indexation. And so what one gets from that is the combination of the fact that the rule is drafted in that way, and invariably this is how it's been done, and we say that that leads to an expectation that these increases will be provided in this way going forward. That's the way we put it. And, my lord, we do also say that the Divisional Court were correct to say that, to deprecate the elevation of form over substance. So that what the Divisional Court said was that the Strasbourg Court does not elevate form over substance, and in circumstances where BT accepts that if the statutory override had been used to achieve the same purpose, that would have engaged Article 1 of Protocol number 1. We say that the deliberate use of a legislative solution designed to try and avoid that conclusion would get nowhere before the Strasbourg Court, because the Strasbourg Court would say, well, what's happening here from the member's perspective, what's happening is exactly the same whether one uses the override or this workaround scheme. Now, the last submission I make on this point is that Ms Rose submitted that the consultation, that even if there were a legitimate expectation, the consultation destroyed the legitimate expectation that the pensioners might have had. And we say that that's a bad point, and I can give you our answer very shortly. As Lord Culmworth said at paragraph 121 of the United Policyholders case, which you saw yesterday, and I don't go back to looking at the time, once a person has a legitimate expectation, the court, and I'm quoting, will require it to be honoured unless the authority is able to show good reasons judged by the court to be proportionate to resolve from it. And we say that merely holding a consultation exercise does not meet this test for resiling from a legitimate expectation. So, my lords, my lady, those are my submissions. I did just want to go back to one point on the factual grounds, and it's a point raised by my lord, the Master of the Rolls, about the 14th of February letter. And I think it was said by Miss Rose yesterday that wasn't taken account of by the court below at all. And she also said the court didn't take account of the 2016 material. Now, on the 2016 material, we say, well, that predates the decision because that relates to the first decision. On the 14th of February letter, we say that postdates the decision.
So the 2016 material predates the consultation.
Predates the consultation. It really was focused on the first interim solution, which was not challenged. The 14th of February letter postdates the relevant decision. It was the government explaining in more detail the decision it had already taken. But in any event, I surmise, I didn't appear below, but I surmise that it was certainly in the bundle before the court, and the court went through all the documents. There's nothing...
I think the criticism was that the court didn't refer to it in its judgment, it didn't deal with it.
Well, my lord, on that, does the court want to see an authority on that? Because I made the submission in response to a question put to me by Lady Justice Davies, which is that it's not incumbent on the court in a judgment to explain, to deal with every single point that's put to the court.
Why don't you just give us the reference?
So,
I mean, I think this is a fairly well-established proposition.
yes, I think it's a well-established proposition.
The court doesn't have to refer to every aspect of the evidence it's referred to. I think
Exactly.
it's quite well-established, but give us the reference.
So there's a recent judgment, so in the matter of Sprint Room Limited, so it's between Prescott and Potamianos, and the neutral citation is 2019 EWCA Civ 932. And
EWCA Civ
932, my lord, and the relevant paragraphs are 77, 84 and 85.
So, what was the first one? 77?
84 and 85, my lord. But the court has anyway my substantive submissions on the letter itself. And unless I can assist any further, those are my submissions.
I'm very grateful to you. Thank you very much. Yes.
May it please the court, I want to cover 4 areas that have been touched on in the oral debate where I hope I can provide some assistance. The first is how sections A and B arose and how they developed over time. Quite a lot's been said about that, but I'd like to put that in simple chronological context. The second is, off the back of that, to explain the effect of the appeal on members and therefore where the interests of different groups lie, which in turn leads to the third point, which is the trustee's role in the litigation and how it's discharged it, including writing 30,000 members, but also touching on the carve-out route, i.e. not getting into the construction issue, and why that's been a route that's settled on, and say something brief about legitimate expectations in that context. And then fourthly, pick up some miscellaneous points, a couple of points on section 109, something very brief about the draft amendment route and a brief update about the trustee keeping members informed. But before I get into that, could I inquire with the court what time it is able to sit until? Because my learned friend has been dealing with questions and run 10 minutes past the slot anticipated.
4:30, is that going to be enough?
Excellent. Well, I will finish by 10 to 4 because I think it's very important I don't encroach on my learned friend's Rose 40 minutes for her reply. Could I hand up 2 documents? The first is a booklet from 1971, albeit a faint copy, that I think is the most accessible way into what sections A and B are doing and how they arise. And the second is the relevant provisions of the Principal Civil Service Pension Scheme that deal with GMPs. So you saw yesterday the 2006 amendment, the Principal Civil Service Scheme, that changed Rule 1.13a, which deals with GMP, so it inserted some new definitions.
Right.
So I've got the provision that is then Rule 1.13a after that amendment, and the main provision which deals with GMPs. I thought that's helpful, particularly as an amendment route has been drafted up, because that amendment route will refer back to those provisions, so you can see how the two sit together.
Thank you.
So starting with the structure of the scheme in chronological order, the key here is that sections A and B arise in 1971 in the Post Office scheme. And those basic provisions are then replicated in the BT pension scheme when that is set up in 1983, and they remain largely, albeit not fully the same, until the present day. So the Post Office scheme was set up in 1969, and that's under the piece of legislation at tab 1 of the Authorities Bundle, the Post Office Act 1969.
It was set up in 1969.
69 under section 43 of the Post Office Act of that year, and that section is set out in tab 1 of the authorities bundle. And that was on the spin-off of the post office from the civil service.
So, just understand that. So the post office was then, what, privatised?
It was a public corporation.
It's a public corporation.
And so people that joined the post office that came across in 1969, it was civil servants, and they had been receiving their pensions under the Superannuation Acts 1965 and 1967. So the 69 Act sets up the post office, and under it the scheme is made by the post office.
It's a public body, and not privatised.
That's right. With the approval of the relevant minister, the scheme is set up. I believe, from recollection, was the Minister for Posts and Telecommunications that was set up under that Act. And the reason you then have a 2-year gap between 1969 and the creation of sections A and B in 1971 is what was happening was a new contributory scheme was being negotiated. And by a contributory scheme, I mean a scheme under which members pay contributions into it to receive their pensions. Because the civil service scheme was a non-contributory arrangement. So what was set up in 1969 by Trust Deed was a scheme with one section that was a non-contributory section that just mirrored entirely the post office scheme. And then by deed in 1971, sections A and B were inserted into that, though those were deeds of amendment. I should say, for completeness, I have the deed from 1971, if you'd like the full
Well, let's see. I don't think it's necessary at the moment. Good. Let's see if we do.
There are some references in my skeleton boast at first instance and on appeal to the various provisions in footnotes, but I sought to give the general narrative in the main body. So the key thing is that Section A was only open to people who had been members of the post office scheme before 1st of December 1971. So it's mostly, but not exclusively, people who had been working in the civil service up to 1969. And there was the basic mirroring provision there right from the start that you've seen. And so Section A was very simple, and it carried across the civil service scheme benefit structure through that mirroring provision.
Was that non-contributory or something?
Well, Section A, the only difference from the civil service scheme was that it was contributory. And the way it worked is that the post office gave you, if you moved into Section A, because you could move from the non-contributory section to Section A, it gave you extra salary to the extent of the contribution that you had to make into Section A. So say, for example, you had a salary of £94 a week and you decided to move the non-contributory section to Section A. The post office would give you £6 more, giving you £100. The contribution rate was 6%, so that £6 would go into the scheme.
Salary would increase?
Yes, you actually get from the post office an increased salary, so that you wouldn't be out of pocket as a result of having to pay a contribution to the post office scheme. And the link to the civil service scheme was entrenched through a restriction in the power of amendment for people who had joined prior to 1969, preventing them receiving different benefits from the civil service scheme without their consent. So with that one gloss in relation to contributions, it was the same as the civil service scheme. As I come on to, a large part of Section A was to form a gateway into Section B, because you might be wondering why on earth was there a Section A on top of the non-contributory section. So Section B was open to people who joined before or after the 1st of December 1971. So many ex-civil servants could join it, but also many new joiners. So anyone who joined between 1971 and 1986 would go straight into Section B. And joining Section A gave you a right to transfer into Section B at any point up to the age of 59. And your normal retirement date was 60, so you could look around at 59.
Until you were 59.
Yes. So you could look around at 59, see whether Section B was better than Section A for you, and decide whether to switch, you see. And that's the origin of some of the letters, because tens of thousands of members have moved across from Section A to Section B. And as you'll see from the booklet I'll show you in a moment, the Section B benefit structure was perceived, as it stood at the time, to be better. And as I understand it, the main reason for that was that the pension was based on the new increased salary that you had. So taking my example of a member who's got a salary of 94 before joining sections A and B, who, because he joins a contributory section, gets his salary going up to 100. So under the civil service scheme, his pension would have been based on a salary of 94, but because he's gone to Section A and then to Section B, his salary is then 100, and so his benefits under Section B are based on a salary of 100.
Why? But I thought you said that your salary increased if you're in Section A.
It did, but then to get into Section, then to you could then move from Section A to Section B. So if you're a member who got into Section A and then went through into Section B, you'd look around at 59, you'd know your Section B benefits could be better in that respect. So, beg your pardon? Yes. Yes. So under Section A, your pensionable pay was your pay after the contributions you made. So in my example, if you were given the £6 extra to go up to 100, your pensionable pay for the purpose of Section A was the 94. So it mirrored the civil service scheme. You got the same level of benefits under the civil service scheme. But if you moved into Section B, your pension...
I may have misunderstood. I thought you were saying you moved from the non-contributory to Section A.
That's right.
Because that would give you then contribute, you then get an increase.
You get an increase in your salary because you have to pay £6 contribution. What you don't get on moving from the non-contributory to Section A is a higher pension, because your pensionable pay, your pensionable pay is still the 94 under Section A, whereas under Section B, it's the...
So Section A, pensionable pay remains the same.
Yeah. So when you see lots of reference in the member responses to having moved from Section A to Section B, that is the...
So under Section B, your pensionable pay is increased.
That's my understanding.
Right.
So generally, Section B did not mirror civil service scheme benefits, but there was negotiation in the early 70s of specific provisions of Section B. Indeed, that's why Section B didn't come along until 1971, when the scheme was set up in 1969. And some of that was put in the bundle before the Divisional Courts, and is in the bundle now. And where that ended up in relation to increases was with the increase rule that is set out in my skeleton at para 16. If I can just show you briefly, the increase rule is in a very similar form. My skeleton is at tab 16 of the core bundle, page 346, para 16. So it's at the top of the page. So that's where the increase rule was at 1971. Any pension payable under Section B should be increased from time to time in accordance with the 1971 Act, or any statutory modification or reenactment of the 1971 Act, as if the pension were payable under the Superannuation Act 65 and 67, there of course not being the 72 Act yet in existence, or any superannuation scheme for the civil service which may replace those acts.
That was the original wording.
So that's the original wording, yeah. Section B. So I'll just very briefly show you the booklet, which contains on one side a helpful explanation of section A and B. So that's the rather faint document that I handed up a few minutes ago.
So what is this document?
This is a booklet from 1971. It's slightly before 1st of December 1971 because the time at which sections A and B arise hasn't yet quite arisen, so it's been written slightly in advance of that. I don't have time for you to go through it, but the relevant page at the bottom is 521, and that's got an explanation of sections A and sections B, and the ability of members to move between them. And then there is then a comparison in the pages that follow of section B versus section A. So, for example, at page 525, about a third of the way down, on the left, section B is on the left, section A is on the right. Pensions will be increased every 2 years as for the civil service. So originally they were increased every 2 years.
525.
525, yeah.
Well, what are we looking at on the left?
So that's the reference, the pension increase rule. Pension will be increased every 2 years as for the civil service. So it was every 2 years at that stage, and then subsequently changed to 1 year when the civil service.
B.
Yeah, that's the section B ones. And for your reference, the negotiation material is at Supplementary Bundle 2, tab 32. Most relevant pages are 348 to 352. And that's written from the union to which branch managers explain the negotiations that are going on with the relevant minister. And what that's bringing out is you've got new terms and conditions for Section B that are not just the civil service terms, but they're specific provisions that are negotiated, and the increased term is one of them. Now, that stage, of course, there is no GMPs. GMP is only a concept created by the Social Security Pensions Act 1975. So at that stage, whether under sections A and B, you're getting a simple increase of the whole of the pensions. So GMPs come along 4 years later in the 75 Act, with effect from 78, and I won't repeat the ground that's been travelled in relation to those. And then through a separate piece of legislation, the Social Security Act 1979, you have section 59A inserted into the 75 Act. Switch on provision. Then in 1983, you have the BT pension scheme created, following the spin-off of BT from the Post Office in 1981, by which I mean a new public corporation, British Telecommunications, was created in 1981 under the British Telecommunications Act of that year. An important point is that when the scheme came to be created under Section 32 of the 81 Act in 83, it was a mirror scheme of the Post Office scheme. So it had the same Sections A and Sections B. I think your Lordship asked at one point when the reference in the Section B increase rule to Section 59A of the 75 Act crept in. The first reference we can find in the chronology is in the 83 rules, 4 years after 59A was introduced into legislation.
It crept in 1983.
Yes, it is possible it could have crept in 1983 into an iteration of the Post Office rules I haven't seen, but it was certainly there in 83 from the inception of the BT scheme. Then BT is privatised in 1984 under the Telecommunications Act, and that means that British Telecommunications, the public corporation, its assets and liabilities get shifted across to a statutory corporation in the private sector. But the important point for our purposes is that doesn't directly affect the benefit structure. That's a change going on at the employer, the company level. At that stage, you've still got just sections A and B. Section B closes to new joiners in 1986. You then have a new BT pension scheme set up that merges into the old scheme in 93 or 94, and into a new Section C. So effectively, Section C are members of the BT scheme that joined after. The BT new pension scheme was created in.
New pension scheme.
Was created.
Amalgamated.
That was then amalgamated into the main scheme in, I think, 93, and into a new Section C. So effectively, Section C members are people that joined the BT scheme after joined BT after 86. And then in turn that scheme was closed to new joiners in 2001.
So they joined after
86.
1986 and closed to new members
In 2001.
2001. Right.
And then for completeness, you've been shown the specific pension increase rule that was inserted into Section A in the same terms as the one in B.
Yes.
I understand that that was inserted into the Section A rules in 2002. What happened was there was a plain English rewrite, an attempt to update the drafting of the rules, and as part of that, Section A, its benefit structure, gets set out in more detail rather than just cross-referring.
What was that year? 2000?
2002, I think, as far as I can tell. And at that stage, the specific pension increase rule is inserted into Section A as part of the Section A benefit structure. So standing back from that, what does one take from that? Well, the basic point is that Section A is quite simple. Apart from the contribution difference from the Principal Civil Service Scheme, it's a straight mirror of the Civil Service Scheme. Section B is slightly more complicated. It's not a mirror of the Civil Service Scheme, but aspects of it are specifically negotiated.
The specific increase provision which mirrors that in Section B was not there originally. It's what you call a kind of a plain language rewrite. Is that it?
Yes, that's my understanding. So I just want to make clear it wasn't at the start, but is introduced later.
Then it came in actually after Section B.
Yeah, that's right. So the Section A rules were very simple originally. As I said, they're mainly just porting over the Civil Service Scheme rules through the mirror provision. That then in turn allows you to see the effect on different members of the appeal and where their interests lie. So if one compares the effect of full indexation through the Section 59A route, the switch-on route, the one that's been adopted, with full indexation through the PCSP amendment route, you look at the different effect on different categories of members. So the route that's been adopted versus the route that BT would like to be adopted. For Section C members, it makes no difference because they don't have an increase rule which is parasitic on the increases legislation. And Section C members are approximately 80,000 out of about 290 to 300,000 of the scheme's membership, to give an idea of scale.
Out of approximately
290 to 300,000 scheme members. So slightly over a quarter. So their interests, if they have interests in this litigation, are in Section B members getting less rather than more, in the same way that if you had a dispute over a benefit structure where one particular group could get more, the other group would have a slight interest in their brethren getting less, because that would mean that if there was a deficit and the worst came to the worst, they'd be getting a greater share of a finite pie.
Yes.
The focus of the appeal is on a certain cohort of Section B members,
Yes.
because they receive, this particular cohort receive a higher pension if you use the Section 59A route compared to on BT's construction of the increase rule if you use the amendment route. So, putting it in less abstract terms, the 8,500 odd Section B members who have a state pension age that's covered by the current HMT decision, state pension age, that falls between 6th of December 18 and 5th of April 21. There were around 8,500 of
6th of December 18 and 5th of December.
5th of April 2021.
These are people who reached state pension age between those dates.
Between those dates, they're the people who
They're the pre-1988. Are they the pre-1988 GMP people?
Yes, to the extent that they have GMP before 1988 or from 1988 to 97 in the event that price inflation exceeds 3%, they get more on BT's construction of the increase rule from HMT's decision to use the Section 59A route compared to using the Civil Service Scheme workarounds.
So they're 8,500.
Yes. That they were the people who BT wrote to in May of last year. There is then a broader category of Section B members who have state pension ages from 5th of December 2018 onwards past 2021, who may be affected by the next decision that HMT takes. When it takes its final decision, they will be affected by them. So there are around, I think, 80,000 members, to give you an idea, who have a state pension age after 5th of April. Sorry. Who have a state pension age after 5th of April 2016. So if you've got a state pension age before then, you're just getting a benefit under the old state pension with the indexation that the state provides, but there are 80,000 people who have a state pension age after that point.
And they're affected by some other decision.
So the first tranche was captured, the 2016 to 18 were captured by the decision made by HMT in 2016. The 18 to 21 lot are caught by the current decision, which is a subject of challenge, and now in due course then needs to be a final decision in respect of people.
Sure.
Sure.
I'm sorry, you know this much better than me.
No, not at all.
Right, so who's caught by the decision that we are concerned?
The 18 to 21 group.
18 to 21 group. Right. And
Sorry.
sorry, yeah. So 18 to 21, a group caught by this.
That's right.
There are 8,500 of those. Then who was caught by who's caught by some other proceedings yet to be brought or being
Well,
brought?
the first interim decision was the 2016 to 2018
That's first
category.
decision. Yes.
How many were in that total? Is that
I think about 10,000, a bit over 10,000.
Right. And then we've got 80,000 who are 21.
So for 2016 onwards, they're about 80. So you probably have about, say, 60,000 who are 2021 onwards. That's quite approximate, but that's just to give you an idea of.
Who said 80,000?
80,000 was from 2016 onwards, so the entire category from 2016 onwards.
The 2021 onwards is
Might
about
be of the
60,000.
order. Might be of the order of about 60,000. Yeah.
Is this in your note? Is this in your note?
Oh yes, Mr. Spencer's witness statement at tab 7 of Supplemental Bundle 1, when he's explaining the 80,000 members who the trustee wrote to, explains the different groups and roughly how many fall into each. And last you've got the section, and so the entire section B is 200,000, I should say. So you're looking at 80 out of 200. And then last you've got the Section A members, all of whom are pre-71.
So the 200 million that BT is talking about, that it will
The
cost,
120 million.
or 120, was it once they were talking about 200 million?
That I think was for the 2016 decision for the group from 16 to 18.
Yes. When you say 16 to 18, these were retired between.
People whose state pension age lay between those dates. So people whose state pension age was before 2016 are covered by the old state pension.
Is it the old state pension? You mean with the AP?
The basic state pension with the AP, yeah, before the single state pension was introduced.
So anyway, you've got, so where we've got to now is, so the 120 million is
That relates to
8,500 people. Yes.
And then lastly, you've got the Section A members. Now, BT accepts, doesn't take issue with the decision to provide full indexation to them. There are only a very small number, I understand, who have a state pension age in the relevant 18 to 21 window. But nevertheless, notice was given to those Section A members who could move to Section B as part of these proceedings by the trustee. So apologies, I'm overrunning slightly, but let me just wrap it up in 5 minutes. So as far as the trustee's stance was concerned, when we received the pre-action letter and then subsequently the claim form, the question we had was whether the claim or elements of it were premised on a particular construction of the Section B increase rule. There were certain elements that weren't, because the claim was broader than it is now. It had lots of elements which were claiming irrationality of certain aspects of decisions, like there was an option Gmp Conversion, which was said to have been irrationally dismissed. So we raised that with BT, and the matter was put before Mr. Justice Ousley, who was deciding the permission application. And what he dealt with, and his order is at tab 11 of file 1.
The supplementary bundle.
Beg your pardon, core bundle.
Core bundle.
Core bundle, tab 11. Yes. And what he decided was that a stock take should be taken after members had been written to and evidence had gone in, and a case management conference should be listed after that to see how to deal with this issue. That duly happened, so BT wrote to a particular cohort, the 5,500, the trustee wrote to the 80,000, and then the responses were received, put in evidence by the trustee, and then the matter was brought back before Mrs. Justice Whipple on the 30th of July, and her order is at tab 11A of the core bundle. And we put both routes to her, the possibility of carving it out or the possibility of getting a member representative to deal with the construction issue, whether within the JR or outside it. And the purpose of the hearing was to check that she was happy with using the carve-out route, because there are a number of disadvantages in seeking to go down the member representative route. Problem one was that until you know what the precise alternative options are, it is quite difficult to test whether they read across. So, for example, at that stage, there was an option called Gmp Conversion, which was one of the things that BT was putting forward, which involved converting the GMP of the Principal Civil Service Scheme. So Civil Service Scheme members no longer had a GMP, so the entirety of their pension was uplifted, but so the argument ran that wouldn't read across to Section B. And that could be done in a number of different ways, some involving primary legislation, some not. Similarly, the wording of the amendment route has been brought out, could be drafted a number of different ways. So it's actually quite difficult at this stage to go and get a decision on the extent of the read across, because the thing you were testing against, the alternative route, was yet to be formulated in that level of detail. So that was the first point. The second point was both parties contended they didn't need to get into it on their cases, and we bore that in mind. We could see points at which the court might have to, but we nonetheless bore in mind the attitude of BT and HMT, which was they didn't think it was a good idea. They far preferred the carve-out route. Thirdly, we were aware that at least if it was dealt with in the JR, it would mean a divisional court deciding a point of occupational pension scheme construction. It would also involve bringing in a Rep Ben, probably couldn't be dealt with in the 2-day listing that had been allocated, and you get into questions about how to constitute the construction proceedings. for example, different Section B members may have slightly different interests. There are people that transferred in from Section A, people went straight into Section B. Lots of different interests there. The pro, obviously, of going down the member representation route is you avoid any risk that the JR could be decided on a basis which would turn out to be false.
There are at least two.
Yeah.
There are at least two arguments that are being advanced, which Ms. Rose is asking
Yeah.
us to resolve them, whether or not she loses other points. So one is whether or not the Superannuation Act can be used in this way to effect the change in question, and that's something that will be challenged by a beneficiary and be affected by it.
Well, that is a point that the government is raising, has put fully, and is running.
That's true.
So there's not a point to which a member can add anything.
And then the other one is the one we just heard about, which is the A1P1 point.
Yes, now the A1P1 point, it started off in the grounds of the Treasury's case as an argument based on historical administrative practice.
And you say that it's been fully argued by but all, in a sense, all that the government has to do is to say it's an arguable point it could take into account. It doesn't have to go so far as to say this is absolutely the law.
That's its case. Its case is you never get to actually having to decide whether there is or isn't.
It is what it is. Let's not rake over
Absolutely.
that ground. This is what's happened.
Absolutely. Well, our point on that is that to the extent you don't need to get into whether there is actually a legitimate expectation, we think it's desirable not to. And to the extent that you do, we think it's desirable to decide it as narrowly as possible, given that the way in which it was run before the Divisional Court at the hearing did get quite close, as BT points out in its appeal skeleton, to the construction issue, which everyone agreed was off limits. There's a lot more I could say on legitimate expectation, but I think I would leave it there, because it's common ground that members, to come what may, still be able to take a construction point, as my learned friend said, still be able to take estoppel points. And so we'd invite you, if you do have to get into legitimate expectation, just to decide on the basis of the argument put to you. You can't possibly hear all the representations that different members have had made to them, and that's probably not justiciable within a single set of proceedings. I'll leave the section 109 and comments on the draft amendment, but could I just ask, would it assist for the trustee to offer any comments of that in due course? I mean, we've received that today. I'm not sure what the court would like to do with it.
Certainly my own practice, I think most of us is not to encourage any submissions after the conclusion of the
Very wise. Very wise.
Unless you do anything. No, I think we're grateful. We're very grateful.
In light of the time, I'll just say by way of update, the trustees obviously kept members informed. Some members may be watching the streaming, and the ministerial direction was actually made on the 4th of December after the hearing, taking effect from the 6th of December. And so pensions have been
4th of December 2018.
18 last year.
That was the ministerial
direction, taking effect from the 6th of December. And so members' pension increases have been put into payment on that basis since then.
No, thank you.
Extremely grateful to you. Thank you very much. Now, Ms. Rose.
Well, it was said by Mr. Dimitriou that the effect of the route that BT is seeking to persuade the government and the court to say was lawful and ought or could have been adopted would be to incur costs to the BT scheme members. But that is a mischaracterisation of the position. Historically, the element of the GMP that is the subject of these proceedings was uprated by the state. It was never uprated by BT. It was uprated by the additional pension. It was the policy of the government to cease doing that. It was the government's decision that members of private occupational pension schemes that had opted out would no longer receive that benefit of the uprating to the GMP. So with great respect to Mr. Dimitriou, that is eliding the two different functions that I identified to the court when I opened my case yesterday. The government wearing its hat of general public government promoting legislation through Parliament, and the government wearing its employer hat. The government's policy in general was the state will no longer uprate GMP, and it will not require private occupational schemes to do so instead. That's for a matter for individual schemes and their members. The state as employer was saying, we've made particular commitments to our civil servants, so therefore we will uprate and fill the gap. And that's why we say that the characterisation here is incorrect. What's in fact happening here is that the state is requiring BT, by the method it has chosen, to provide a benefit to members that the state itself is no longer providing and not requiring any other private employer to provide. And there is therefore in our submission an inconsistency between the stance taken in these proceedings, which is, oh well, it's inappropriate to prefer BT's financial interests to the interests of scheme members, and the general government policy, which was precisely that, to prefer the interests of private employers to their employees, by saying, we're no longer going to uprate GMP, but we're not going to require private pension schemes to do so either. And that's the disadvantage to BT, that it uniquely is going to suffer that disadvantage amongst all its competitors. Now, my learned friend made some submissions about doubt about the effectiveness of the PCSPS amendment route. I don't want to labour this because it's not in my submission relevant to the issues that are before this court. But she stresses Rule 13.2 of Section A, which is the rule in Section A that refers to the increases legislation. But she's looking in the wrong place, because the key provision, and I'm afraid I was heckling, is Rules 1 and Rule 6 of Section A, because it's Rule 1 that sets out the general principle that Section A is to mirror the maximum benefits available under the PCSPS, and it's Rule 6 that makes it clear that all Section A members are entitled either to the best benefits they can get under the PCSPS or the best benefits under Section A, whichever is more advantageous. And so therefore, it's perfectly clear that any amendment to the PCSPS that provided for uprating under the PCSPS would apply to Section A members. The fact that Section A, at a late stage, after Section B was drafted, also included a read across for pensions increases legislation is neither here nor there. The legal test for findings of fact challenges. In my submission, it's not a Wednesbury test. If you look at the Henderson judgment, paragraph 67, it's made clear that Wednesbury is, as it were, the fallback position, and that's in a situation where you're not identifying a failure to take account of relevant material or a misreading of the evidence in a way that it can't reasonably bear. And as the court knows, our complaint in this case is essentially that precisely those are the flaws that we identify in the Divisional Court's judgment. Now, it's said, oh well, the Divisional Court was under no obligation to refer to every single document. And of course that's right. But there is also a very strong line of case law that this court will be very familiar with, that it is incumbent on courts to refer to sufficient material to make clear the reasons why a party has won or lost. And in this case, the court failed to refer to the critical documents that are inconsistent with the construction that the court placed on the communications. Not only the February letter, but the very wording of the decision itself, paragraph 3.19, and the evidence of the government's own witness, Mr. Kirk. No reference to his evidence, no reference to the decision, no reference to the supplementary reasons that were specifically given to BT after it inquired for the reasons for the decision. That brings me then to the question of issue 1. And my learned friend says, oh, well, you can just ignore.
I just want to make sure I
Yes.
So you said there's no reference to the terms of the decision itself.
Yes, I'm talking here specifically about issue 1.
Yeah, no.
Yes. The Divisional Court relies on two matters. The
Well,
first...
I just want to get down the ones you say haven't been.
Yes,
There's no reference to the wedding decision itself. There's no reference to Mr. Kirk's evidence.
Yes.
There was no reference, you said, to supplementary material.
Yes, that's the 14th of February letter. That was the supplementary reason. So that the decision letter comes out, BT writes to the Treasury and says, we want further reasons, please. And the Treasury then writes to BT with further reasons, and that's the 14th of February letter.
Right, and anything else?
And yes, the other material is the material that predates the consultation. The rake letter, the notes of the meeting, the interchanges between the parties and the QC's opinion. All of that engagement in 2016. None of that's referred to. All that the Divisional Court refers to is paragraph 1.11 of BT's consultation response and paragraphs 12 and 18 of the November submission. And in our submission, that is inadequate. Now, even when you look at the documents they do refer to, they don't refer to the critical parts. So in relation to BT's consultation response, they refer to paragraph 1.11 and 3.2c, but they don't refer to paragraphs 2.8 and 3.2b, which are the paragraphs which make it clear.
3.8, 3.2,
This is BT's consultation response. 2.8 and 3.2b, which are the paragraphs in which BT makes it clear that it considers that the PCSPS workaround would avoid the adverse impact on it.
I'm sorry to interject, but they did actually, as a matter of fact, refer to 3.2b, and we see that in paragraph 115.
I'm talking about in the passage where they explain why they reject BT's submissions, the actual reasons for their decision, which are at paragraphs 120 to 122. So the effect of what they've done is, first of all, to consider BT's consultation response as if it comes out of a clear blue sky without there having been prior engagement, and then to ignore the actual wording of the decision, the supplementary reasons and the evidence of the government. And we say that that's a serious enough flaw to mean that their decision can't stand, and to entitle this court to make its own assessment in the round of what actually BT was saying and what it was understood by the government as saying. Now, my learned friend says, oh, well, the 2016 material predated the consultation, and she says it was about the first decision. That's incorrect, because the first decision was made on the 1st of March. The rake letter, which is the first time that the PCSPS amendment route is raised, is the 8th of March. It's after that decision. And the meetings and all of the engagement that you saw were exchanged after that. And the culmination of that was the letter that the court saw from the Treasury saying, we're going to look at this in the context of the consultation. We're going to take it forward in the context of the consultation. So although it's right that the formal consultation paper is then published, BT has already been in extensive engagement with the government, and they know what BT are proposing. And then my learned friend said, oh, well, why isn't there a detailed exposition of the PCSPS route in the consultation response? And the answer is because BT has already had detailed discussions with the Treasury about that issue. And the court saw the emails recording those discussions and knows that there were meetings at which matters were fully debated. There was no reason for BT to repeat matters that it had already aired with the Treasury. And the effect of the court's below's decision is to ignore all of that context. She then said, oh, well, the annex to the consultation response only dealt with the statutory override. Indeed, it did. That was the purpose of the annex. BT was certainly asking for the statutory override. BT's position was, you can avoid the adverse impact on us, either by the PCSPS route or other primary legislation, but in order to avoid potential legal uncertainty, we urge you also to use the statutory override. And BT accepted that the statutory override would impact on property rights because it would involve amending the BT pension scheme rules, and that's why there's an annex from Freshfields investigating the question of the justification for that interference. So it's hardly surprising that that annex is not addressing the PCS amendment. That's not what it's about. And my learned friend failed to address the basic question, which is why on earth would it be rational for BT to say, unless we can have total legal certainty that this route is effective, we want total certainty that we will suffer the adverse impact. We're not prepared to take the PCSPS route, which we think will be good enough, although somebody might challenge it. That's an irrational position. So that's the overarching point. Now, the detail, my lord, in relation to the November submission, if we just go back to the supplementary bundle 2, tab 26. Now, what my learned friend says, if you go to paragraph 12, it's at page 286, she says, oh well, the fact that it says or, amending the 74 Civil Service Scheme or providing a statutory override is neither here nor there. And that's essentially what the Divisional Court says in the crucial paragraph of its judgment. But what the Divisional Court didn't address, and neither did my learned friend, was the following sentence. Treasury legal advisors advise that in each case there would need to be a policy justification for preferring the interests of BT to the interests of the scheme members. So it's not just the use of or, it's the statement in each case. And that is wholly inconsistent with the construction that is now being put by the Treasury on this, and that the court below put on it. And the court did not consider the meaning of in each case. She then said, oh well, there was no consideration at any stage of whether the PCSPS route would interfere with property rights, because the government never considered that as a freestanding proposition. My lord, it's right here in this paragraph, because the very sentence we're looking at says, the legal advisors advise that in each case, there would need to be a policy justification for preferring the interests of BT to the interests of the scheme members. The scheme rules have the result that members are entitled to benefit from a Treasury direction in the same way as members of the 74 Civil Service Scheme, and there would need to be a legally defensible justification for interfering with BT scheme members' property rights. And that's the part that was originally redacted and then unredacted. And what is clear in my submission, beyond any doubt, from that paragraph, is that what is being said to ministers is that the statutory override or the PCSPS route would interfere with property rights, and therefore there would have to be a justification for them, separately. It's the only way you can read this paragraph. And then when you go over the page, at 13, the legal advisors say it might be possible to devise a mechanism to avoid impacting on schemes such as BT. So it's saying there might be other ways of doing it. It's not even limiting itself to the ways that have been put forward. But then it says, however, that would require identifying a legally defensible justification for the interference in property rights. It's perfectly clear that what they're saying requires further legal investigation is not whether there would be an interference with property rights, but whether there would be a justification for an interference with property rights. The whole decision proceeds on the assumption that they have already concluded that any of these routes would interfere with property rights, and therefore the question is whether there's a justification. It's clear from paragraph 12 and it's clear from 13. It's then clear again at 15. Legal risk is high. A judicial review brought by members of or trade unions is likely, and unless we were able to develop a defensible justification for interfering in property rights, there's a high risk of it being successful.
We've draw attention to those.
Yes,
paragraphs.
but my Lord, my point is that you cannot read that, first of all, as not considering the PCSPS as a separate option. And you cannot read it as not deciding that the PCSPS would interfere with property rights. Those are the two explicit premises. And you then see that, not surprisingly, in the decision itself. Because the government's evidence was that the decision was a distillation of what was in the November submission. So when you go to the decision in the core bundle, at 3.19, page 303, tab 12, what you see here, it says, the other consultee requested that the government should craft its response. 303, paragraph 3.19.
Thank you.
So this is the critical passage in the decision itself. The other consultee requested that the government should craft its response in such a way as to avoid the read across from public service schemes to their private sector scheme. Now, my lord, that is not apt to describe the legislative override, or certainly not solely the legislative override. What it's talking about is any method that will avoid a read across. So that encompasses the legislative override, another piece of primary legislation, or the PCSPS amendment route. All of those options, which we've already seen enumerated in the submission, come within that definition. And then what we're told is the government believes it would not be appropriate in a way that would deprive members of indexation to which they would otherwise be entitled. And I stress the word deprive to what they would otherwise be entitled. Because that's the whole basis on which the government is looking at this. That they have an entitlement that they're being deprived of. Acting to do so would also raise legal questions, including whether there was a legitimate aim to justify such an interference in the property rights. So again, it's very clear that the premise is that this would be an interference. The only question is legitimate justification. And the final doubt as to whether this is talking about each of the options is dispelled by the final sentence. In addition, some of the mechanisms suggested by the consultee to avoid this impact are outside the scope of the government's statutory powers. And it's Mr. Kirk's evidence that that sentence refers to the PCSPS amendment route. So this paragraph is explicitly rejecting all of the mechanisms on the basis that they interfere with property rights and the PCSPS amendment route on the additional ground that it's ultra vires. And we say again, on the basis of this paragraph, it simply cannot be found as a fact either that they were not considering the PCSPS amendment route separately, or that they were not assuming there'd be an interference with property rights. Such an interference. Now, it's right that they say as a matter of policy would be inappropriate to deprive, and that takes me to the point that you can't make that decision weighing the competing interests unless you properly characterise the interests. And if you've wrongly characterised it as a deprivation of an entitlement, then you're not conducting a lawful weighing exercise. And finally, the letter of the 14th of February, my lord, we say puts the matter beyond doubt. Because in that letter, it's supplementary bundle 1, tab 3, page 56. You put forward several proposals as to how the government could deliver its policy objectives. One would involve primary legislation providing for a statutory override. Another would be to make changes to the PCSPS. All such proposals would involve the government acting against members' interests and so on, and then the same language about deprivation of indexation to which they would be entitled. And we say that's simply making clear what's already clear from paragraph 12 of the November submission and paragraph 3.19 of the judgment. And I'm not going to take you back to paragraphs 5 and 6 of Mr. Kirk's second witness statement, but they are of a piece. Now, the reason that witness statement was put in, my lord, is that when we received disclosure of the November consultation, of the November submission, our witness said it looks from this as though the PCSPS amendment route wasn't put to ministers, because the question at paragraph 18 is focused on legislation. And Mr. Kirk said, oh no, that's wrong. The PCSPS amendment route was put to ministers. And he also said at the end of paragraph 6 of his witness statement, if we hadn't rejected it for policy reasons, we'd have considered all of BT's proposals, including anything else we could have devised. So their colours were nailed to the mast of saying this was a policy decision that's severable from property rights. They weren't saying this was a decision that never considered the PCSPS amendment route. Now, my learned friend says that it was pleaded, paragraph 91. Lord, I don't have time to go to the pleading, but that's not right. It's paragraphs 83 to 91 of the defendant's defence. What you will see in those paragraphs is that the Treasury put forward 4 reasons why BT's judicial review claim should be rejected. The first was that the PCSPS amendment route was ultra vires. The second was that they hadn't made a decision about the engagement of property rights, they'd only raised it. The third was that in any event property rights were engaged and there'd be an interference. And my lord, I'm going to have to turn it up to remember the fourth. It's at tab 9 of the core bundle. So the second was it's a policy decision. The third was we never decided property rights, and the fourth was anyway property rights were engaged. Those were the 4 reasons. One of the reasons was not you never raised PCSPS as a separate rule. All they said at 91 was, oh well, you said we'd need a statutory override and that would interfere with property rights. That's all. So well, that's issue 1. So far as issue 2 is concerned, we accept there was a policy reason, and our complaint is that that policy reason is not severable from the question of property rights, because as we've just seen from the key documents, the policy reason was premised on the assumption that there was an interference with property rights. And so that was the members' interest that had to be weighed against BT's interest. And the court will recall that I contrasted the wording of the Divisional Court judgment with the wording of the decision, because you'll see that the decision talks about depriving members of benefits to which they were otherwise entitled, and the court softens that to saying, preventing members from obtaining benefits. So the Divisional Court seeks to equate members not getting benefits in the future, which they might otherwise have got, with a deprivation of an entitlement, and they're completely different things. Just to give your lordship and your ladyship the reference to the decision, it's in the core bundle. It's judgment paragraph 130, page 61, where they say if the government did so, the consequence would be Section B members would not get the pension benefits which they would otherwise obtain.
Paragraph 130.
Paragraph 130. Saying someone will not get the benefit they would otherwise obtain is very different from saying they will be deprived of the benefit they would otherwise be entitled to.
Sorry, what was the reference in the decision?
Yes, in the decision it's 3.19, my lord. It's the same paragraph.
Oh, the same paragraph.
Yes, and the same language is used on the 14th of February.
Yes.
Both of those documents talk about depriving members of the benefits they were entitled to, the indexation they were entitled to.
Thank you.
So that's ground 2. And of course, the decision also crucially talks about such property rights. So it specifically characterises deprivation of indexation to which they would otherwise be entitled as a property right.
What are the particular words in 130 you're referring to?
Sorry, 130 of the judgment, my lord.
What's the word here? Is the sentence that the section B members would not get the pension benefits?
Yes, where they would not get the pension benefits they would otherwise obtain. Whereas what the decision talks about is depriving them of the indexation to which they would otherwise be entitled, and then says such property rights. And that follows from the characterisation at paragraphs 12, 13 and 15 of the November submission. So that's ground 2. Ground 3, I don't know if your lordships and your ladyship are allowed to sit, able to sit for another 10 minutes. Only I was. I'm very grateful, thank you. This is not a bespoke statutory scheme for this situation. That's the single headline point. A duty on the minister to provide a minimum uprating to all public sector pensions to account for inflation across the board is not the same thing as a power to provide more generous provision to any individual public sector pension scheme through the Superannuation Act. And there is no conflict between the general duty to provide that minimum uplift across the board and the broad power to make rules for pension schemes, including bespoke rules for increases for particular schemes. The Benyon maxim, on which my learned friend relies on which the Divisional Court also relies, if we can just turn it up, it's in Authorities Bundle 3, tab 58. Generalia specialibus non derogant. What that means is general matters do not derogate from special provisions. But if the general provision is not derogating from the special provision, this maxim is not engaged. And here, the general power to make rules for pension schemes, including rules concerning uplifts, doesn't derogate from the general duty to provide a minimum uplift to all pension schemes. Now, what my learned friend then says is, well, if it's not right that 59 and 59A are the exhaustive scheme for all purposes, at the very least, they are designed to cover this situation. Again, not correct. The first point is, there is no legal principle that if a public authority has powers to act under two statutory schemes, that it has any duty to use one rather than the other in any particular situation. And that is Lord Neuberger in Cusack. If we just turn up Cusack, which is at tab...
I think we saw that thing. We've seen it.
Let me just show you, Lordship, the relevant paragraph, which I'm not sure if your Lordship's seen. It's at tab 43, and it's paragraph 28. He is quoting here Lord Reed from the Westminster Bank case. So this is page 1171. He's quoting Lord Reed. Here the authority did not act in excess of power in deciding to proceed by way of refusal of planning permission rather than by way of prescribing an improvement line. Did it then act in abuse of power? I do not think so. Parliament has chosen to set up two different ways of preventing development which would interfere with schemes for street widening. It must have been aware that one involved paying compensation but the other did not. Nevertheless, it expressed no preference and imposed no limit on the use of either. No doubt there might be special circumstances which make it unreasonable or an abuse of power to use one of these methods, but here there were none. So here there is a power under section 59A to provide increases to public sector, to classes or cases for the GMP element. And there's also a general power under the Superannuation Act to make rules for pension schemes. There's no reason to regard one power as taking priority over the other. More specifically, it is with respect wrong to regard section 59 and 59A as in any sense the bespoke statutory scheme for this purpose, for the purpose of uprating the GMP element of pensions. On the contrary, section 59.5 is drafted on the supposition that in general the uprating of the GMP element of pensions is not for this regime. That's the whole premise of 59.5, is to carve out GMP uprating from this regime. And the reason it's carved out from this regime is that this regime presupposes the existence of the AP regime. So the whole climate in which this legislation is enacted is that uprating of GMPs is not to be dealt with under this legislation, but under separate legislation. And with respect, it's very difficult in that situation to see how suddenly this becomes, either legally or through the improper purpose doctrine, the only legal or proper way to provide an uplift to GMP element. It's inconsistent with the whole structure of the scheme. What you have at section 59A is a provision that's intended to plug gaps in the GMP provision, but that was never designed to provide the whole of GMP uprating. The way that the 59A power has now been exercised renders 59.5 wholly OTOs, because there is no class of case now that falls within 59.5. The exception has swamped the rule. Now, that doesn't lead me to say that that was ultra vires. I accept that cases or classes of cases are very wide power. But what I say is a very strange submission is to say that that novel and unprecedented use of the 59A power is to be regarded as so much the sole bespoke, lawful, proper way to do it, that the alternative statutory power in the Superannuation Act cannot lawfully or legitimately be used. That's a very remarkable proposition. Indeed, the natural power, if there is a natural power, it's the Superannuation Act. Because what you would normally expect, if the Secretary of State had made an assurance to one public sector pension scheme, you'll get a particular uprating in excess of the minimum, you'd expect that to be dealt with through those scheme rules. Let's say that the commitments the government was honouring here had only been made to the PCSPS, not to the members of all public sector schemes. Then the natural way of uprating would be through the scheme rules, not through section 59A. Now, you might be able to do it through either. You could say that they were the class of case under 59A. But who is to say which is more natural? This is a case where there are two powers and both are available. Now, what my learned friend then said was that BT was not seeking to persuade the government to give more generous provision than the 75 Act provided, but seeking to do exactly what the 75 Act required. Well, that is wrong. What the 75 Act requires is uprating in accordance with inflation, excluding the GMP element. That's section 59 and 59.5. What she is relying on is not what the 75 Act requires, but the discretionary power that it introduces under 59A to close the gaps caused by 59.5. So that submission, we say, is wrong. Then she says that the increases legislation occupies the field in relation to increases. Your Lordships and your Ladyship already have my submission that 59 and 59A don't set a maximum, they just set the floor, that section 17 of the 71 Act makes it clear that the basic rate that's referred to under section 59.5 includes the pension as increased by other legislation or other routes that are not legislative. So that's inconsistent with the increases legislation being the only way you can increase pensions. there was no need for Parliament to say anything more specific in the 72 Act. It had given a broad and general power. And giving a public authority a duty to do X does not extinguish its statutory power to do X plus Y. I think I have, my lord. And your lordship has our points that, in fact, the regimes were the AP and Section 109, they were never this regime. Ground 4, we say, when one analyses it, is based on the same errors as ground 3. And that once ground 3 fails as a matter of vires, there's no separate basis for saying improper purpose. The way my learned friend now puts it is that it is in some way improper to prefer BT's interests to the interests of the pensioners. But why is that improper? But it's not improper to prefer the interests of the pensioners to the interests of BT. That makes no sense. The reality is that once the government appreciated, first, it had the power to make this change by either route. Secondly, that its policy was to honour commitments to public sector scheme members that didn't include BT's pensioners. Third, that one route would extend the obligation to BT and the other wouldn't. The government had to decide how to weigh the relative interests. And that's a question of proper discretion to which there are two possible answers. So we accept that, in principle, lawfully, the government could have used either route. And that's why we say, ultimately, the question is, did the government conduct a lawful exercise weighing the relative interests? And it didn't, because it wrongly took the interest on one side of the scale to be a property right. But there's no impropriety here at all. If you ask what's the purpose of the 72 Act, the purpose of the 72 Act is to make and amend pension schemes, and that's precisely the purpose for which it was being used here, in order to implement a government policy to honour a commitment made to a specific group of pension scheme members. That's perfectly proper. And that, again, one can see from the passage in Cusack we've just looked at. My learned friend relied on paragraph 142 of the judgment, which is at the core bundle, tab 5, paragraph 63, for the fact that it had always been used. Well, what it glided over, she said, oh, well, in 2016 it was a somewhat wider class. That's what the Divisional Court said. It's not a wider class, it's everybody. Then finally, ground 5. The court already has my submission that it's wrong to say this was never considered. The decision was made on the assumption that it was engaged and that the only question was whether it was justified to interfere with it. We submit that there is no basis for a legitimate expectation here for the following reasons. First, the scheme rule only gives a right to increases made under section 59 and 59A. Second, ex hypothesi, there is also a power to give increases under Section 2 of the Superannuation Act. Third, the indexation of GMP is traditionally done via the AP in Section 109, not 59 and 59A. And fourth, it is not said that any assurance has been given that all indexation will always be done under 59 or 59A. In that situation, how could... Yes, no assurance that any indexation would be under 59 and 59, either from the government or from BT. Of course, BT wouldn't have been in a position to give that assurance because it's not up to them. So what is being said is that the mere inclusion of this rule sets up a legitimate expectation that the government, a third party, won't use the statutory power it has at any time in the future. Well, that's an impossible proposition with respect. It will not, it can't be sustained. How can there be a legitimate expectation in that situation that the GMP, which is not dealt with under Section 59 anyway, but primarily through other routes, will only ever be indexed under the increases legislation? That would be inconsistent with the scheme that was being operated at the time, which was AP and 109. And how could there be a legitimate expectation that the government would never use the statutory power it had? My learned friend says, oh, well, that's the obvious assumption. of 10.2, and that's what the court said, but of course the assumption is the exact opposite. If the obvious assumption was any indexation of the PCSPS by any route will be received by these pensioners, why specify one particular piece of legislation? It's unnecessary.
I think we've now reached the past.
My Lord, is there any other particular issue that you would want me to address before I sit down?
We're grateful.
I'm grateful.
We appreciate that a lot of ground has been covered by all council, and we are very appreciative of the way in which that's been done. There's a lot of material with great speed, but in an extremely helpful way. So we're grateful to all leading council in this case, and of course all those who assisted them and sit behind them. We will consider our judgments in this matter in the usual way. When you receive the judgments, apart from making corrections for grammar only and textual amendments, hopefully, the jury does make any further submissions in writing, and please agree that formal order. Thank you very much.
You had more than your 40 minutes. You had more than
I had not. I had not.
Look at the time. Look at the time.
I had
We all
40
need a bit
41
longer.
minutes.
You know,